And in 2994 is when the second degree murder was. Is that correct?
I was arrested the night of the 23rd and then charged with murder while I was in jail.
You were in jail when you were charged with murder, right?
Yes, sir.
Okay. All right. As I go that, I want you to give the board just something real brief about what all happened in your words.
I had gone out drinking with some friends, and gradually as the night wore on, I met a woman and we connected, and later on we were parked out beside the river, and from the best of my recollection, she just started screaming and yelling that I raped her, and I panicked and I shot her.
You had never knew her before, right?
No, sir.
And after you shot her, what happened?
I covered her body up with some brush and went home, and a couple of days later, I brought a friend over in that area and told him what had happened. And that eventually led to me getting arrested for DWI and charged with murder.
Right. That's what I want to make sure you tell the board, to make sure they know. I know they all got to sign, but the murder happened before that. And then when you got to DWI's, when you came back and gave your statement, right?
Yes, sir.
Okay. What is your job title? Where you at the prison right now?
I work for the range crew.
For the range crew?
Yes, sir.
How long you been working with the range crew?
Off and on for about 5 years now.
That's a pretty trusted position there where you working at now at the range crew. How long have you been incarcerated totally?
I believe 28 years.
28 years. And is there Warden's anything you had to say on your behalf?
Yeah, he has been back and forth in and out of range crew for the last 5 years, which, like you said, that is a trusted position for us. He's been at the incinerator for a while. He's been in some other areas, but those were for institutional need. So the time out of the range crew has been because we needed him other places. But still, it's been outside of the fence, and he's been doing good work for us.
Right. Well, thank you, Mr. You know, as I see here, you got your GED back in '99, and also your welding at the state penitentiary, the NCR certificates, in tutor in welding. You had great vocational training while you've been there through prison enterprise. You worked in game bird management. Well, that's good. You've done a lot of good things there. And then I look back down here where you've done your 100 hours pre-release, substance abuse, living in balance, thinking for a change, victim awareness, including a letter accountability. You've had some good programs since you've been incarcerated. You've had 4 disciplinary write-ups, and it's a trusted position. I see where you're at there. So I don't have any more, anything else I'd like to ask.
Thank you, Mr. Wise. Ms. Jackson has some questions. Ms. Jackson?
How you doing, Mr. Morrow?
Good evening.
I haven't heard a lot about your transition plan. If you were to be granted early release, then what?
Well, I've been in contact with Carrie Myers at the probation project, and
Project?
yes, ma'am. And plan to work with them through that, getting transitioned back into society.
Have they taken you on as a client?
They said that once we get through this process right here, that then they would take me on for the parole thing, because they only work with the parole.
Well, Okay. Where would you live? I mean, where would you like to live?
I had things set up to live with my aunt in Leesville, but those plans fell through and I'm engaged to be married to a woman that lives in Texas. So we're planning to transfer to Texas.
Why did the plans with your aunt fall through?
Primarily, she's getting up in age and health reasons and stuff like that. And I just felt it would be too much of a strain on her.
And who is your girlfriend and how did you meet her and how long have you been in a relationship with her?
Her name is Casey Tatum, and I met her through a pen pal program, and we've been together approximately about 6 years now.
Have you ever met her personally? Has she ever
Yes.
been?
Yes, ma'am. She's been on my visiting list for years now.
And she's come and visited?
Yes, ma'am. She would be on here as somebody for me today, but she had surgery this morning, so she wasn't able to participate.
And where does she live in Texas?
She lives in Midland, Texas.
And what does she do for a living?
She works for the state of Texas. She
And
works
what,
social
what-
services.
all right. And tell me what kind of work you would do.
Well, her father, which would be my future father-in-law, owns a oil field fabrication company, or he's part owner in an oil field fabrication company. So I'd be welding for him.
All right, thank you. That's all I have, Ms. Renatza.
Thank you, Mr. Jackson. That's what I was going to ask you, Mr. Morrow, is where's your family? But you just explained at least why your fiance is not here today. I don't see any other questions by my colleagues. Is there a statement you'd like to make to us before we vote?
I just want to thank y'all for the opportunity to present myself and express, my regrets that it even had to come to this right here.
All right. Thank you, sir. I believe we're prepared to vote. Mr. Wise will be voting first.
At this time, I'm gonna be voting. I'm gonna vote to grant with immediate parole eligibility. You've done some good, very good programs. I see you also, you've been working in a very trusted position where you at. You've had 4 disciplinary write-ups. So, and good luck with this, because I know you still got a long way to go. You have another, if the governor was to do this, you'd still have to go before the parole board. Okay,
Thank you, sir.
So that was a commute to 99 years with immediate parole
Yeah.
eligibility?
I grant to commute to 99.
Okay,
Immediate
thank
parole.
you. Mr. Roche?
Madam Chairman,
Yes, sir.
my vote is to commute to 99 years with parole eligibility after serving 30 years.
All right, thank you, sir. Mr. Marabella?
Mr. Morrow, you've been in 27 years, is that right?
27 or 28.
Okay. After listening to the interview, looking at your record, your low risk, the comments by the warden, and the work that you have done there, my vote is likewise going to be commute with immediate parole eligibility. Commute to 99 years with immediate parole eligibility.
Thank you, Mr. Marabella. Ms. Jackson?
All right, Ms. Morrow, I will confess that I'm a little bit concerned about your explanation of the crime. Why she would accuse you of rape if you met her in a bar and you all agreed consensually to have sex, and why that would have prompted you to take her life. I will tell you, I'm really concerned about that. but you have been in almost 30 years. Unfortunately, the victim is really forgotten in this. She has no family here in Louisiana. There was nobody to reach out. They had no way of really identifying her or who her family was. But you have been a trustee for 11 years. You're in a trusted position. Your risk assessment is low, and I guess the most impressive thing is that you've only had 4 write-ups in your time that you've been there, and you did seem in your statement to be genuinely remorseful. And so for that reason, I will I vote to commute to 99 years with immediate parole eligibility.
Thank you, ma'am.
All right, thank you, Ms. Jackson and Mr. Morrow. I do concur with my colleagues. My vote today would also be to commute to 99 years and with immediate parole eligibility. So, sir, we'll make that recommendation on your behalf to the governor. Good luck to you.
Thank y'all. Good evening.
Well, I don't have anything to unpack with this in terms of like court records or anything. All I can say is thank you, Ms. Jackson, for bringing up the victim, which you rightfully said there's no representation in this case, wasn't even brought up. I agree that to think that someone 27 years later would still have a story that makes absolutely no sense. Oh, we went out to the bar. She started accusing me of it, so I shot her. It's like, well, maybe it's more likely that, like, that's probably what you were doing, and then you shot her because you didn't want anyone to know. I mean, the whole story is probably so much, and I think people should be held accountable. My always viewpoint on this is if you can't come out and speak the truth, then you shouldn't get rewarded. And his story about his way that he believes it happened just makes no sense. And it's just further like diminishing his responsibility in crime. I also didn't see any remorse. And if you lie, you can't have remorse. I don't get that part. I don't get how they reward someone who seems to clearly be lying. That just how that can possibly be your story is something I can't understand. But I don't have, I guess they just wanted to commute. He's been locked up a long time, and that's it. I don't know what else to say. But I guess what I can say, maybe the governor felt the same way. According to his record, he's still in Angola. So, what normally happens, they make a recommendation to the governor signs it, then he has a parole hearing and he gets out. And either the governor signed it with conditions to serve 30 years, and we'll see a parole hearing come up any day now, or he just denied it. So isn't that interesting? I mean, it's not every day the governor would deny a commutation recommendation by a unanimous board that he handpicks to make these decisions. I don't know the answer, but thank you, Richard, for putting this together. And with that, I'll let you go.
Brent, as she mentioned, I'll read some information into the record. I ask you to verify that information, and then I'm going to turn it over to Mr. Marabella because your case has been assigned to him. Okay?
All right.
Okay. So you are Leon Brent. Your DOC number is 74779. You're classified as a first felony offender. You're here because you submitted a commutation, a request for commutation of your sentence. You were out of East Baton Rouge Parish in November of 1964, sentenced to death for an aggravated rape conviction. You were resentenced in 1971 to life. Mr. Brent, is that information correct?
I was resentenced in 1973.
1973. Well, thank you, sir. All right. Would you answer Mr. Marabella's questions?
Thank you, Madam Chairman. Mr. Brent, my name is Tony Marabella. Your case has been assigned to me, so I'll be the panel member that talks with you first. Okay, can you hear me?
Yes, sir.
Okay. Mr. Brent, how old are you? You're not quite 82, is that right?
81,
81. You'll be 82 soon, is that right?
December the 22nd,
All right. And how long have you been in prison?
58 years.
And you were, by my calculations, 23, 24 when this occurred?
Right. 23.
Mr. Brent, I don't want to dwell a lot on the facts of the case, but I do want to talk a little bit about them because up until then, you had a couple of misdemeanor charges. Tell me what prompted you to commit this vicious rape?
I really don't know myself. Because that wasn't part of my nature. It's just something that just happened for the moment.
Well, what do you mean it just happened on the spur of the moment? Tell
It
me
wasn't-
what you remember about what happened.
Well, I remember going into an office and accosting a white lady. And after that, I was arrested.
You say accosted her, you raped her, you had a knife, right?
I didn't rape her. I had a knife, but I didn't rape her. I had the knife.
What did you do? You say you didn't rape her, you were convicted of aggravated rape.
I have, yeah. When I went in that office, I started to rape her, but I quit. I stopped.
You say you started to rape her. What does that mean? You know, the legal rape is, doesn't mean you have to finish the rape. You remember going in there. What did you go to that office for?
I was passing by the office. I used to go up to that building when I was working downtown at Bush Jewelers. I used to go up to a building to take jewelry to Mr. Madare, Jewel Madare. And I used to pass the office all the time.
Now, Mr. Brent, you've been in prison for a long time and you've taken a lot of programs and I see all of the things that you've done. Have you given any thought to what you did to that lady that day and what pain and what terror that must have caused to her?
Yes, sir.
Tell me about that.
In many years. And I'm very, very remorseful for what the pain that I caused her and her family, and my family also. And if I could erase that, I would erase it, but it's something that it was just a bad situation that happened. And I'm just, I know she was devastated and I was devastated myself because, like I said, that wasn't a part of my nature. That just, I really can't explain what caused me to do that myself.
Were you on alcohol? Were you drinking? Were you taking drugs?
I never drank before in my life. I never used drugs before in my life.
You were 23 years old. Were you married? Did you have a relationship?
I had a wife. I had been married 4 months and 2 months and 19 days.
Did you know this lady before? This was just some stranger you walked into a building and decided to rape?
No, I didn't know her, but I saw her a couple of times by going to Mr. Madare to take jury.
Where did you get the knife?
I was working at Bush Jewelers. I had the knife peeled and passed for one of the ladies in the office. And I just put it in my back pocket. When the manager gave me this jury to take to Madare, I just put the knife in my back pocket and left out with Mr. Madare's office.
Tell me, in the 58 years you've been in prison, what's the best? You've taken a lot of programs. What's the best programs or what has helped you the most while you've been in there?
Thinking for a change.
Okay, tell me about that.
Well, this type of program that teaches you to think before you do things, to make decisions after you analyze situations. You just don't go headlong into everything. It's a program that gives you the teaches you how to make good decisions.
Now, you quit school in the 11th grade, I believe. Is that right?
I did.
You got your GED while you've been in prison?
Yes, sir.
I think in 1975 you got your GED?
Yes, sir.
What kind of jobs have you had while you've been in prison? What kind of work have you done?
The first job I had was classification clerk. I was a classification clerk up here
Okay.
for the main prison that I did parole board preparations. Next job, other jobs I had was groundkeepers, where I used to keep the ground, keep grass, cut, plant flowers, and something like beautification.
Are you still doing that? I understand you've had that since 2012. Are you still doing that?
Yes, I am.
So that's the job you currently have?
Yes, sir.
What is your status? Are you a trustee?
Yes, sir.
How long have you been a trustee?
Since I think 2008.
Okay. Now, I notice in the programs that you've taken, one of the programs that you've taken is you've taken all 4 phases of the sex offender treatment program. Tell me what you learned in those programs, in that specific program about sex offender. What sort of things did you learn or have you come to acknowledge and realize having taken the sex offender treatment program?
A sex offender treatment program, it starts off teaching you about what prompts you to do, commit such a crime. It gives you, it helps you to realize the factors that will play into you committing this type of crime. It also have a word list where it gives you words that you would recognize, things that you would recognize to help you realize that you are about to commit another crime, a sex crime. And it teaches you how to understand these what would be warning signs for you, to turn you aware, to make you realize that you're about to do something that you shouldn't do.
Did it also talk about the effects that a rape has on the victims?
Yes, it does.
Your victim in this case is no longer, she's dead now, but she suffered for years and years as a result of this. Do you realize that? Do you understand that?
Yes, sir. I do realize that.
What would you
And
say to her if she were here?
I don't know if I could say anything to change what happened or to make her feel any better, but I would let her know that I was really, really devastated myself for what I did to her. And I'm sorry that she had to go through the type of life that she went through after this happened to her. And if it was any kind of way that I could correct this and make things better for her, I would gladly do it if it had to, if I could.
Now, you've had 75 write-ups. That sounds like a lot, but you've been in prison for 58 years. You haven't had a write-up in 2009, is that right?
I think so.
What were some of the write-ups you got? What were some of the things that you did when you were in prison?
Most of them was for work-related write-ups. I had a few for fighting. It was the type of write-ups where you're working in the field and some days you just don't feel like working. And I've had a couple of insubordination write-ups where I talk bad to security, curse security.
But you haven't done anything like that since at least 2009.
No, sir, I haven't. You know, it's in prison. When you come to prison, I was young when I came to prison, and when you get to prison, it's a lot of things that you have to face. And by me being so young, one of the things that you face in prison is you want to always look want to try to keep yourself on a status where you're not, what I would say, stepped on or walked over.
I understand.
You know, so, and my trying to stay on the upside, it got me into a lot of trouble. But as years go on, you mellow out, you find out that you can get past most of this trouble by just using everyday common sense.
What kind of associations did you have while you were in prison? I know you did Inside Out Dads. You did CPR and first aid. Did you work with anybody within the prison system to help them out or anything?
Well, I took the courses, but in most instances, they have what you call people that teaches the class. Most of them do all of that. I never had a chance to do CPR, but I did CPR once on an older man when I was at Camp C. But the rank came and they took over and did it themselves. I took these courses mostly to be able to use them when I have to use them. It's something for a tool, you know, you never can tell when you would have to use these courses.
Now you've been up for pardon, look, 1, 2, 3, 4, 5, about six times or so, haven't you?
Yes, sir.
And you continue to do well. Is the warden there? Let me get some information from the warden about how you're doing.
Yes, sir. He has been, since December of 2010, a minimum B, which would be because of the charge, the highest that he would ever be able to attain as far as that minimum custody status. He's been out at Camp F, which is our trustee dorm, or trustee camp rather, since 2012, and has continued to be a groundskeeper for us. He has been in and out of our hospital. He does have frequent appointments with primary care as well as some specialty care, mostly related to the fact that we're all getting older. But other than that, like he said, his last write-up being of such in 2009, have not had any other issues.
Thank you, Warden. Mr. Brent, tell me a little bit about your health. You're about to be 82 years old. You look like you're in pretty good shape as you sit there. Tell me about your physical health.
My physical health is fine. I do a lot of physical things. I work out a lot. I run a lot. And since I've been in prison, I had 2 operations for hernias. Other than that, I have what you call minor cases of high blood pressure. I'm not in the place where I just have to sit around and wait to die. I try to keep my health and thing in good type of shape.
Mr. Brent, tell me in your own words why I should vote to let you out.
Well, I'm 81 years old, and I've done 58 years in prison. Over those years, I've had nephews, great nieces that come into my family that I never spent any time with. And I would like to, whatever time that I have left, I would like to be able to go home and spend some quality time with them, and get to know them, and get to learn them, do different things with them. And by me being here in prison, it's just, my life has been wasted, and it's because of me. And it might be something that I might be able to do to go out in the street and maybe help them and guide them and keep them from getting into the same any kind of trouble that I've gotten into. I might be maybe some kind of inspiration to them. I may be able to give them some information to help them. And that's one of the reasons why I really would like to get out of prison. If I'd be able to spend some time with my family members before my time expires.
If you were to get out at some point, where would you live?
Well, I got a number of places I could live. One mainly with my sister-in-law in Los Angeles, California. She have a garage apartment. She told me whenever I get out of prison, I could come out there and stay in the garage apartment. And that's where most of my nieces, great nieces and nephews stay. And I could, you know, be of some help to her since my brother passed away.
Thank you, Mr. Brent. Madam Chairman, that's all the questions that I have.
Thank you,
Sir.
Mr. Mayor. Thank you, Mr. Marabella. Now we'll hear from the folks who are here today in support. First, we'll start with Bliss George. If you could unmute your microphone, please.
Good afternoon to the board and all others. My name is Bliss George. I live in Baton Rouge. I'm a second cousin of Leon's Brent. On my father's side, I would like to say that when this happened, I was only 8 years old. I heard different things. So as the family died off, his parents, my parents, that used to be his visitors, brothers, after they all passed off, we came in contact with him, I think at one of the rodeos. So we started to visit, my husband and I, and my sister. And I got to know him, because like I said, I was only 8 years old when this happened. So I got to know him as a person, and I started visiting him in Angola. And I can truly say that I enjoyed the visits. He informed me on the background of the family, things that I didn't know, that whereas family members had died off. I also, we talked on various subjects, from health to the Bible, just all different subjects. And I was impressed, to say the least, on the knowledge that he had gained. And I'm sure, and I know that this knowledge that he got was taking advantage of the programs that was offered at Angola. And so with all the visits, I can truly say that I think if he was released, he would truly be an asset to the society. Thank you.
Thank you, Ms. George. Can we hear now from sister-in-law, Ms. Brent, Ms. Emma Brent?
Yes, my name is Emma Brent. I'm a resident of Los Angeles, California. I married Leon's brother in 1974, and I've only had a few visits with him there at Angola physically. But we talk on the phone every week, and he's been a real encouragement to my family. My husband died 10 years ago, and because of that, my children were devastated. But to have their uncle to talk to them when he would call, it was an encouragement for them. I truly believe that if he were to be released, that he would be a great benefit to them. He's been very encouraging to me. And we do have things set in motion now that if he is able to be released and come to California, that we'll be able to help him with employment. One of my stepchildren is a former Los Angeles policeman who has his own security business, and he's guaranteed employment for him. This would be the type of security that does not involve any kind of weapons. And I have a place where he can stay. And as he mentioned earlier, that most of his nieces and nephews are here in Los Angeles, and it would be beneficial to all of us. I feel like the time that he has served and the time that we have spoken about this situation has been more than sufficient. And that he'll be a benefit to not only our family, but to the entire community, because he has a lot of experience and positive things that he can share. Thank you so much.
Thank you, Miss Emma. We appreciate your input. Mr. Brent, is there anything else you'd like to say to the board?
Yes,
All right.
I would like to say to the board that I'm truly remorseful about what happened. And I take full responsibility for what happened. But I would also like to be able, I would like for the board to give me an opportunity to go home, be able to spend some time with my family, and to just spend the rest of the few years, whatever I have left, helping them and being of service to them, and maybe to some other people in the community.
Thank you, sir. The board's prepared to vote. We'll start with Mr. Marabella.
Thank you, Madam Chairman. Mr. Brandt, the crime of rape is devastating on the victim. Ms. Kleber suffered for years and years, both physically and emotionally, as a result of what you did. You've had time to reflect on this. You know, I know you've been in prison for a long time, and I know you've taken a lot of good classes, but I'm not sure, even as long as you've been in prison, you really get the gravity of what you did to that lady, and how it affected her life. Yes, you've been in prison all of these years. Yes, you've been affected, obviously, but you committed that crime. And she suffered for years and years as a result of what you did to her. You've taken our sex offender courses. You're very articulate. I'm not sure what I was expecting when I saw your age as almost 82 years old. I was very pleased to see how spry you are, and how well you communicate. You know, I see that. You've done a lot of positive things while you've been in prison. You've got a lot of good family support. You do have law enforcement opposition to your release. You have a good recommendation from the warden. Your disciplinary record has been very good for the last 11 to 12 years. I want you to think more about that victim. I want you to look inside a little more and realize maybe not only how this has affected you, but how this has affected her in her entire life. You've been in prison for 58 years. I'm going to go ahead and I believe that it's probably time for you to be able to think about getting out. You've done well in prison. My only problem that I have right now is maybe you're reflecting on what happened to that victim in this case. So my vote today is going to be to commute your sentence to 99 years and make you immediately parole eligible, primarily because of all of the things you've done. You're going to be 82 years old in just a little bit. You've got excellent family support, and you've got good comments by the warden. So that would be my vote, Madam Chairman.
Thank you, Mr. Marabella. Ms. Jackson.
All right, Mr. Brent, if I live as long as you have, I hope that I'd be in as good a shape as you are, and I hope I would have the mental faculties that you have. And we've seen men in prison who are not nearly as old as you, but prison has, really worn them down. But you didn't let that happen. You stayed positive, you took care of yourself, you performed well in prison. You have a low risk assessment, you have excellent family support. I can't imagine what it must have been like for those 10 years when you had the death sentence hanging over you. Those years had to have been really hard. But I think you overcame all of that. You've done well. And my vote today is to grant a commutation to 99 years with immediate parole eligibility.
Thank you, Ms. Jackson. Mr. Wise?
Well, at this time, I'm going to be voting to grant commutation 99 years with immediate parole eligibility. You've been, one reason is because of your age, and you've been 58 years incarcerated in some of the programs you took, positive programs you've taken, also with a low risk. So thank you very much.
Thank you, Mr. Wise. Mr. Roche?
Thank you, Madam Chairman. Mr. Brent, excuse me, Mr. Brent, I want to echo everything my colleagues have said this afternoon, but I want to add one thing. I am sitting here in amazement at the sharpness of your mind, the breadth of your knowledge. As Mr. Marabella, I looked at your age and says, she will be 82 years old next month, which is sharp as any 30-year-old. Your memory is terrific. And I need to know your secrets. My vote is the same, to commute to 99 years with immediate parole eligibility. Good luck.
All right, Mr. Brent. First, let me just start off, Ms. Dupree, by apologizing. I passed over your comments, and I do apologize for that. But my vote also is the same, Mr. Brent. My vote would be to recommend commutation to 99 years with immediate parole eligibility. And I just echo all the remarks that have already been made. So good luck to you, sir. We're going to make that recommendation on your behalf to Governor Edwards. Thanks, everybody, for participating. And again, Ms. Dupree, my apology.
Thank all of you.
Okay, so certainly an interesting case, one that might even be studied. And also what I want to point out is that here is a man who was put on death row, as Ms. Jackson had stated, had spent 10 years on death row, and now has been commuted and is free. And why that is so important is that recently we have seen many death row cases. For the previous governor had put up all of these inmates who had done the most horrible crimes, who are sitting on death row, and they were asking to have their death row sentence commuted. Not that they would be commuted to be set free, but just so that they would be taken off of death row. And something that we saw falsely, erroneously stated by those death row inmates' defense attorneys were, we are not asking for this person to ever be free. They will never be free. They're going from death row to general population. So why are you all so worried about it? And we had a few of the prosecuting attorneys say, no, that's not the case. This is their first bite at the apple. They can then come back for a second bite of the apple. Mr. O'Shea actually stated this, and then get commuted. And we had heard their attorneys say, no, that's never happened. And we know it's happened. We've seen it. They just completely lied intentionally, or just unaware of the many cases that we've seen, this being one of them. This is someone who was on death row, was taken off, and now is set to be free. Whether you think you should or not, that's a different point. But I did want to bring that up. Now, here's another, I guess, controversial part of his appeal. They were saying that it was race motivated, that's part of the reason why he got the death penalty. you can make your own conclusion on that. But we'll also go over what he claims happened, which is, but so thirdly, the petitioner complains that the district attorney made certain inflammatory remarks before the jury, and particularly he contends that since he is a member of the African American race, and that the jury was an all-white jury, that the district attorney should not have referred to the sexual assault victim as white girl. So petitioner does not now argue or contend before this court that the jury was improperly selected, nor did he urge any such claims before the court, Louisiana. Actually, no substantial ground upon which to base his argument for the issuance of writ habeas corpus, other than one relative to the alleged improper introduction of evidence pertaining to the prior convictions, which is hereafter discussed. As to the remarks made by the district attorney, inflammatory. There is no merit in this contention. After all, the victim of the crime took the stand. She took the stand as a witness, and is quite apparently to the jury that she was a white girl. That's what they're saying. Like, it shouldn't have made a difference that the attorney said that. Although, if I'm going to share my 2 cents, I mean, at the time that this crime took place, to deny that there's probably racial divide in 1967 Louisiana, you'd have to be in denial. I mean, there's a reason they gave him the death penalty, right? There was no prejudice to the defending resulting from this reference to the victim of the crime. The record disclosed no other evidence of unlawful prejudicial remarks having been made before the jury. The defense counsel freely admitted during the hearing before the court that there was little merit of any of these 3 contentions. They were urged, however, of any abundance of caution that could merit these contentions. It is petitioner's contention that he had admitted that he had been convicted of prior offenses. The questioning should have ended there. Instead, the district attorney not only questioned petitioner about the details of his prior convictions, but also presented the testimony of the victim of a prior offense, who was also a white girl. The introduction of the evidence took place as follows. The state did not attempt to introduce the evidence of prior convictions during its case in chief, but when the defendant voluntarily took the witness stand, the district attorney on cross-examination questioned him as to a prior conviction. The court properly limited the questioning to questions pertaining to convictions as distinguished from arrests or offenses. The petitioner admitted that he had been convicted of disorderly conduct and sentenced to serve 60 days. He was then asked by the district attorney, what was this disorderly conviction as a result of you insulting a white girl? This was objected to by the counsel for petitioner, who contended that when the petitioner admitted a prior conviction, no evidence could be introduced concerning the details of the offense for which he had been convicted. The court overruled this objection and stated under the law of Louisiana, attorney could produce evidence pertaining to other convictions, but not as prior arrests or offenses. The district attorney then proceeded to produce evidence of both by cross-examination of petitioner and later by a rebuttal witness to show that the prior conviction involved a mode of operation used by the defendant most exactly the same as testified by the complaining witness in this case. The complaining witness in this case had testified that the petitioner came into the office. Okay, so here is what the witness said had happened in this case, and it is a horrible crime. And his excuse for it is a joke, and the idea that he took the stand seems very unwise, questionable to say the least. I mean, how the attorney could have allowed that. I mean, if he insists, he insists. You can't stop it, but you'll see what I mean. So the complaining witness in this case had testified that the petitioner came into the office where she was working alone and asked her if her boss was there. He said he was looking for a job cleaning offices. He then looked toward a back room and asked what was there, and she told him a storeroom. He said that as he was looking for a job cleaning up offices, he would like to look at the back room. He then gave her what he claimed to be his name, which was actually a fictitious name, and asked if she would have her boss call him when he came back. While she was writing the name and number down, the petitioner locked the front door of the office, looked around to see no one was in the offices and then grabbed her, brandishing a knife, forced her into the back room where he proceeded to sexually assault her and later cut her with the knife. He then tied her with a rope and left her bleeding on the floor. So that's what he did to her. Now, his story, on the other hand, was that he did, in fact, have sexual contact with the complaining witness, but he insists that there was no actual penetration or sexual assault occurred. Now, this part is interesting because it is the same as to what he's stating today, and that is interesting. He stated that but here's where it just gets ridiculous. He stated that she enticed him into her office, ordered him to have intercourse with her, and threatened him with calling the police and claiming that he had sexually assaulted her if he did not do as she ordered. He also admitted cutting her with a knife and tying her up before he left the premises. So, yeah, I mean, imagine if you're his defense attorney and he says, I'm going to go up there in the stand and say that's what happened. It's like, oh, come on. The purpose of the testimony concerning the prior conviction was to show that the approach used by the petitioner on a prior occasion involving a different victim was a similar approach to that he alleged by the complaining witness to have used in this case. So the prior victim, he did something similar? Is that what they're saying? Whether or not the introduction of evidence violated the law of the state of Louisiana, if of no moment in this habeas corpus proceeding, the only question is whether or not he violated federally protected rights. The question must be answered in the negative. I don't know enough about law and stuff to know whether or not they could have brought that up, whether that was admissible. Bringing it up and alluding to it being a part of a hate crime, I don't know. No idea. But it is interesting that you would get the death penalty for this. I don't know if they handed them out like candy back in Louisiana. I don't know. I don't know enough to comment, but what do you think? He is now free and he's still, as far as I can tell from the records, kicking and screaming, as in very much alive. But yeah, love to hear your thoughts on this, and thank you, Richard, for the information. And with that,
3, classified as a third felony offender. Offenses: possession of methamphetamines, illegal possession of stolen things. Sentencing date: February 6, 2018. Revoked on August 25th, 2020. Sentenced to 10 years. Parole date is April 20th, 2022. Good time is November 19, 2022, and full term is November 21st, 2027. Is this information correct?
Yes, ma'am.
Mr. Roche.
Thank you, Mr. Reeson. Good morning, Ms. Cox.
Good morning, sir.
Good. Good morning, Ms. Bauer.
Good morning.
Ms. Cox, I'm going to read some information into the record. And we're going to have a conversation, so just relax. And we're going to try to find out just a little bit more information about you so we can make an informed decision, okay?
Yes, sir.
Okay. Ms. Cox, you are a third felony offender with at least 8 arrests, mostly for drugs and theft and some violence. You're currently 47 years old and you've served 4 years on a 10-year sentence. And you were just revoked 11 months ago, is that correct?
Yes, sir.
In August of 2020. for, you failed to complete the 30th JDC drug program.
Yes, sir.
What happened, Ms. Cox?
My daughter had escaped from work release, and while I was in drug court, they thought that maybe they thought I had helped her escape. And so they arrested me, and I stayed in jail for 9 days. And because I was incarcerated, it kicked me out of drug court. And then because of my probation, that was a stipulation of my probation was to complete drug court, they violated me on probation.
How's your daughter doing now?
She's doing great. They did catch her, and she's serving her time.
Good, good. You have a low risk assessment, but your needs high assessment, you have a high needs assessment.
Yes, sir.
So I'm going to ask you about some programs, and I want to know if you completed those programs, okay?
Yes, sir.
Have you completed any type of long-term substance abuse program?
I've completed a program here at the place where I'm sorry, I'm nervous. I completed a program of substance abuse while I was here.
So you completed the Louisiana Transitional Center program.
Yes.
When did you complete that program?
June the 15th.
This year.
Yes, sir.
Okay, tell me the 3 most important things that you got from that program.
The most important thing I feel that I got, that there is help out there. There is people that are willing to help an addict. Second thing was through my drug abuse, I learned that because of me being sexually abused as a child, it plays a big role in my substance abuse. And third, I know that I can stay clean with the help of someone else. I know I can't do it alone, but with the help of another program or outside meetings or something, I can stay clean.
Okay, now, I was going to get to this later, but let's cover it right now. Give me your plan for sobriety. How do you plan to stay away from drugs and alcohol?
First thing is to stay away from the people that I used to hang with. Second, I've got to find me a sponsor, and I've got to make some meetings and stay focused on my sobriety and stay going to meetings, stay around people that is going to be uplifting and not bringing me down, and mainly and go to church. I noticed while I was in church that I stayed clean for the longest.
So you're gonna change people, places, and things.
Yes, sir.
Okay, great. Have you completed the anger management program?
I have an LCIW, but I haven't during this day.
You enroll now?
No, sir. I'm waiting for DLC to put me into classes.
That's all right. I'll take care of that today.
Thank you.
And have you taken 100 hours pre-release?
No, sir.
Those are 10. That course has 10 subjects that will cover everything that you need to be successful when you're released.
Yes, sir.
And I'll take care of that today too.
Thank you, sir.
What's your job at the facility?
I don't have one, sir.
So you're in classes.
Yes, sir.
When was your last disciplinary write-up?
I haven't had a disciplinary write-up. I have one for my mattress.
It was thrown out.
It was thrown out.
Yes,
Okay.
sir.
It was a number 17, Miss Valerie?
Yes, sir, but it was basically a misunderstanding. They thought she had stitched up the mattress where it was a stitch from the factory.
Okay. So is that your only disciplinary write-up this?
Yes, sir. Yes,
So
sir.
you've only had that one in 4 years and it's been dismissed.
Yes, sir.
Good. Tell us what your transition plan is. Where do you plan to live and where do you plan to work?
I have my own place where I'm from in Leesville. I have my own place that my mom passed away and left for me. So I plan on staying there. I also have my brother, he has a business of his own, air conditioning and heating company, and he told me that if I kept my nose clean and stayed off drugs, that he would give me a position.
Good. Good brother.
Yes, sir.
You see, he put this stipulation there.
Yes, sir, he did.
He was not going to aid in the bed.
And he told me he was gonna give me drug screen, so that's a big step for me.
Okay. So you have a place to stay, you have a place to work. Okay. You have a sobriety plan.
Yes, sir.
Look like everything's shaping up.
Yes, sir.
Mr. Wise, that completes my interview.
Thank you very much. No one else to speak there. Jessica, how you doing?
I'm doing good, Mr. Wise. How are you doing?
Doing good. I hadn't saw you in a long time. I didn't know where you'd went.
Well, I kind of messed up,
I hear you.
but I'm gonna get it together.
I hear you. All right, at this time, anything you'd like to say to the board before we vote?
No, sir, I don't.
Okay, thank you very much. At this time, I'll be voting be Mr. Alvin Roche. This case was assigned to him.
Thank you, Mr. Wise. Ms. Cox,
Yes, sir.
I think you have all your ducks in a row. I'm going to grant your early release
Thank you, sir.
after completion of the anger management class and 100 hours pre-release.
Thank you, sir.
By my putting those conditions on, DOC will immediately enroll you in those classes.
Okay.
And after you successfully complete those classes and your parole eligibility date has passed, you will be released.
Thank you, sir.
Upon release, you'll have a curfew from 9 p.m. to 6 a.m. You are to attend at least 3 NAAA meetings a week. And I want you to do some community service, get with your pastor, get with your parole officer, and I want you to do 5 hours a month giving back to the community.
Yes, sir.
Good luck.
Thank you, sir.
Mr. Marabella?
Ms. Cox, I have listened intently to Mr. Roche's interview and his presentation, and I agree with all that he has said. My vote today likewise would be to conditionally grant your parole after you complete anger management and 100 hours of pre-release with the same conditions as he has outlined for you. So good luck to you, ma'am.
Thank you, sir.
Mr. Wise, you're muted. Mr. Wise?
Okay, at this time, I'm gonna be voting to grant for the same conditions stated. Let me tell you something, get this behind you, man. I know some of you family, you come from a good family, get all this behind you.
Yes, sir.
What's your brother's name?
Charles Emerson?
Yeah, I know Mr. Charles.
Yes, sir.
Okay. All right. Thank you very much.
Thank you, Mr.
That'll
White.
conclude our hearings. That'll conclude our hearings there.
Well, I can't help but feel that this was something to do with. It's not like you tried to hide it, but maybe, maybe some family, some deep South family loyalty here. I mean, it really certainly seemed like Mr. Jim Wise knew her brother, or her brother's on the force or something. He's like, "Who's your brother?" "Oh yeah, I know him." And he didn't even say grant. They never officially went through the process on the record of granting because Jim Wise forgot to do that. Now sometimes that happens and they'll make a correction on the record at the end of the day or the following day or that following week. We've seen that happen. They'll have like an official thing before the next parole hearing starts and they'll correct the record or go over the minutes. And correct it. It's got a little confusing what we just watched. Keep in mind, it seems that she had just gotten revoked 9 months later. It's just hard for me to believe that anyone would have a chance of getting paroled after being revoked 9 months earlier on these type of charges and scenario. And today's parole board, I just don't think we've ever seen it. Now, maybe it happens and no, I don't think we've ever seen it. Let's be real. But okay. She's, we haven't seen her yet. I Googled her one last time before doing this little hearing. We haven't seen her. I can give you this is from one arrest in 2017. This is another. She's smiling and everything in her arrest pictures. Good for her, right? This is 2018. So, and that's pretty much it. It doesn't say for what. But I don't know. I don't really have anything else to add here, except that hopefully she's actually doing well because I haven't seen her again. So, if we do see her again, we'll have this to go back to as a reference and we'll re-upload it on the playlist that says return of. It's the return of playlist. So if someone is revoked or has a second parole hearing, we combine the hearings and put it there. Thank you, Richard, as usual. And with that, I'll let you go.
You are classified as a fourth felony offender. You're currently serving a 40-year sentence. You were sentenced possession with intent to distribute heroin in 2013, also in 2013, possession of a firearm by a convicted felon. In January 2014, you were sentenced as a habitual offender for distribution of heroin. And then also in June of 2014, attempted possession of a firearm. Your parole eligibility date was September 2nd, 2023, and your good time date is in 2052. Is all that sound correct to you?
Yes, ma'am.
Your case is assigned to Mr. Roche. Would you answer his questions?
Thank you, Madam Chairman. Good afternoon, Mr. Meloso. How are you?
All right, sir.
Good. Mr. Meloso, you are currently 42 years old, is that correct?
Could you repeat that for me, sir?
You're currently 42 years old, is that correct?
Yes, sir.
And you've been convicted of 4 different felonies, is that correct?
Yes, sir.
And the felony you're now serving a 40 years sentence for is distribution of heroin, and you were billed as an official offender, is that correct?
Yes, sir.
Can you tell me what the other 3 felony convictions so far?
Possession of cocaine.
All 3 of them?
Yes, sir. And distribution of cocaine.
So all 4 of your felony convictions dealing with drugs?
Yes, sir.
Were you a drug dealer or a drug user?
I was a dealer, sir.
You If you ever used illegal drugs?
No, sir.
So you've never even smoked a marijuana cigarette?
When I was like 16,
And that's illegal. When you were 16, that was illegal. So
yes,
I
sir.
ask my question again. Have you ever used illegal drugs?
Yes, sir.
You started with marijuana. Did you graduate to anything stronger?
No, sir.
And what did you sell to people in your community?
Heroin and cocaine, sir.
Why didn't you use heroin and cocaine?
I saw the effects of it, the damaging effects of it.
But you still made a livelihood selling the poison to the community, and you knew the effects that it would have on the people that you sold to.
Yes, sir. Yes, it was. It was a terrible decision and poor decision. Yes, sir.
Have you ever had a legitimate full-time job working 40 hours a week, paying taxes?
Yes, sir.
Tell me what you did.
I was a truck driver, sir.
And
Operating.
how long did you drive trucks?
I drove trucks for 2 years, sir.
So you're 42 years old, and you were a truck driver for 2 years.
Also, I also worked as a bagger at Winn-Dixie for like 2 years when I was younger, 18, when I was 18, sir.
So what kind of work did you do between the ages of 20 and the time you were incarcerated?
Could you repeat that for me, sir?
What type of work besides driving a truck did you do between the ages of 20 and the time that you were incarcerated?
I worked in the field. I did different labor jobs when I was released.
So you spent a lot of time incarcerated.
Yes, sir.
How long do you think you've been incarcerated out of the 42 years?
Probably like 3 years.
How long you been incarcerated out of? Altogether. In the 42 years you've been, how old you are?
Like 18 years.
That's how long you've been incarcerated.
18 years.
You've been incarcerated 10 years this time on a 40-year sentence, is that correct?
Yes, sir.
So you've been incarcerated 8 years prior to this incarceration.
8 years, like 8 to 9 years, sir. Yes, sir.
So tell me the programs that you've completed in the 10 years of incarceration.
I have Cage Eraser, GD, Living in Balance, Parenting, 100 Hours, Problem Solving, Anger Management, IC3, Serve Safe, I have Victim Awareness, Spiritual Awareness, Government Affairs.
First of all, congratulations on earning your GED.
Yes, sir.
And you've been busy. Programs are not your problem. And we're going to get to your problem, your number one problem, a little bit later. Are you a trustee at Raymond?
No, sir. At the time, I have too much time, but I am. I do work. I work as a stock clerk in the canteen, and also I'm a facilitator, sir.
Okay. If I would ask Warden Bickham why you're not a trustee, will you tell me the same thing?
Yes, sir.
Okay. Are we going to discuss what I think is the reason that you're not a trustee right now? But let's talk about your current job assignment. What is your current job assignment?
I work in the canteen as the stock clerk, sir.
A very trusted position. Let me go to your progress report. Yes. If your most current progress report said that you're housed in medium custody. Is there a reason why it's in medium instead of minimum custody one?
No, sir.
You asking me, Mr. Roche?
Yes.
He's got too much time to be a trustee. Our facility is, anything under 12 years.
Okay, okay. And why is he in minimum custody?
Sir?
Why is he in medium custody?
We have minimum, medium, and maximum, and the trustee's minimum. And he's not
Okay.
eligible for that based on time.
Okay, thank you. Okay. And you went over your programs. Your transition plan is with Ms. Connie Poston, aunt. Tell me about the transition plan.
My transition plan, I currently has a interstate compact pending, and I plan to move to Texas with my sister. And my aunt, she just was on my residency plan because the address that I had listed is a high crime area, and I have no desire whatsoever to be a part of those type of communities.
Okay. Now, one second. Let's talk about your real problem. You don't follow rules and regulations. You have 10 disciplinary write-ups, 10 disciplinary write-ups in 21 and 22. You have an abundance of aggravated disobedience, a fight. Tell me why so many disciplinary write-ups.
Well, at that time, sir, I was in a facility where the facility, these facilities are full of younger guys that's younger than me. And sometimes, being in prison, you're put in a position where whenever you're working for the administration and you're not living to certain people's standards, you're put in a position where some things are unavoidable. And at that time in 2021, I had been at that facility for a few years and I was looking for a new beginning, sir. And even though I went about it the wrong way and I regret it, I truly regret the behavior that I was displaying at that time. But I was really trying to get closer to a facility, closer to my family. And, I just, now I find myself, mentoring some of those same younger guys now because, I understand with me taking rehabilitative programs and changing my mindset, it helps me and allow me to deal with certain situations without, displaying destructive behavior.
Ms. Malone, I've been on this board for 8 years. I'm well acquainted with Raymond M. It's a good institution. Most of those inmates don't have multiple write-ups. You have 1, 2, 3, 4, 5, 6, 7, 8 aggravated disobedience within 1 year. And then after you got to Raymond, you had 2 additional write-ups in 2022. How do you explain that?
It's no justification for it. I apologize. I mean, I work on every day. It's an ongoing process for me to work on my behavior, and, I'm a strong advocate of doing what's right. Today, I'm a changed person, sir.
Yeah.
This
is also a disciplinary system in DOC helps the wardens control the population. And when a person gets multiple write-ups within 1 year, a year and a half of his parole eligibility date, I'm concerned because you're being watched 24 hours a day. And you still not follow the rules. In aggravated disobedience, it's a very serious infraction. And if we release individuals who are constantly breaking the rules, it sends the wrong message. And I'm going to tell you very frankly, I cannot vote for your early release because of your disciplinary conduct. It's unacceptable. I'd like to see at least 2 or 3 years where you're right up free and you're doing everything that you're supposed to do. Mr. Meloso, you have an excellent record of programs. You have 825 hours of good time. You've taken all the basic programs, but your conduct is not acceptable. I want you to, I'm only one vote. But if we deny you today, I want you to continue doing what you're doing and stay right up free for another 12 months and then reapply. Madam Chairman?
Thank you, Mr. Rocho. Mr. Melanson, did you, when you were in where you got all the write-ups, did you ever write for a geographical transfer? Did you write a letter?
Yes, ma'am. I did write a letter.
How many
Yes, ma'am.
times?
I wrote it once. I wrote it twice now. Twice.
Well, don't you think you could have used better decision-making and to intentionally get the write-ups to effect a transfer?
Yes, ma'am. And I gratefully
You see that now, but I do note that since you've been there at Rayburn, you've had 2 low court write-ups.
yes, ma'am.
So you still got to work on it, but you're doing better. Warden Bickham, is there anything you want to add?
Pretty much covered everything. He is, he did have 2 write-ups here for being in the wrong dorm. He is one of our facilitators for some of our classes, and he's working on getting to be a certified mentor.
Good, good. Thank you. All right, we have some folks that I didn't recognize early on that have joined us and want to speak. We have Mr. Melonson's sister, Micaiah Melonson. We'd like to hear from you now. Is your microphone on mute? There we go.
Oh, I'm sorry. Trying to do 2 things at one time. My son just graduated from.
Congratulations. Good.
Thank you. Okay.
What do you want us to know?
Okay. So thank you. First of all, thank you for giving me the opportunity to speak today in regards of my brother matter. Honorable members of the parole board today. My name is Micaiah Melonson, and I will be speaking out today to address the matter of my brother Raymond Melonson's parole. I want to make it abundantly clear that I hold my brother accountable for his actions. Despite never having experienced incarceration myself or fully understanding its realities, while I may lack firsthand knowledge of prison life, I firmly believe in giving my brother a chance at redemption and rehabilitation. I am hopeful that the parole board will also extend him this opportunity. I recognize the importance of his potential role in mentoring my 16-year-old and 13-year-old sons, but I want to assure you that I will not go easy on him. Again, I will not go easy on him. I understand the significance of setting appropriate boundaries, expectations, and consequences. My primary objective is to ensure the other comprehends the gravity of his past actions and fully understands the responsibility he holds in being a positive influence on my children as well as his own children. I kindly request the parole board's consideration in granting my brother the opportunity to prove himself, to demonstrate his commitment to change, and to contribute positivity to society. With the right support and guidance, I believe he can make a meaningful difference in the life of others. And I think he have learned from his past mistakes. Thank you for listening to my statement.
Yes, ma'am, and thank you for joining us today. We appreciate your input.
No
We
problem.
also have Mr. Melancon's daughter, Rochelle Dorsey. Rochelle, would you like to speak now?
Hi, how y'all doing?
Good.
I just wanted to say thank y'all for giving me the opportunity to speak on my dad's behalf. And this is a sad moment for me, and it's a happy moment because I haven't seen my dad in years. It's so sad to see him wasn't able to see me walk across the stage for graduation. And I also just got my license in dental assistance. And even though I'm able to talk to him every day, but I will appreciate if he gets to see me physically. He plays a big role in my life.
Mm-hmm.
And I do this to make him and my mom proud. And I'm just hoping and praying that he comes home.
Well, congratulations on your achievements, and thank you for speaking with us today. I know it means a lot to your dad too.
Thank you.
And Mr. Carter, Arthur Carter, a friend, would you like to speak now?
Yes, ma'am. Can you hear me?
We can.
Okay, my name is Arthur Carter. I'm formerly incarcerated, and I was incarcerated with Raymond. And I want to introduce Raymond to you because way back in 2012, 2013, we was housed in Louisiana State Penitentiary in Angola. And we had a class where we wasn't doing nothing but teaching guys post-conviction articles. What I want to bring to this board attention is what Melanson brought to us. He brought us an opportunity to kind of like examine ourselves and make the correct decision. We started taking cases and reading them way greater than just the dictum and the issues. We read on what the propensity of the case was. Why honorable judges like Ms. Johnson would write, in her opinion, things that she would write. The societal interest, the penal interest, the public safety. But anyway, at the end of the day, we began to kind of like reflect on activities that we were involved in. Activity that was acceptable in the communities that we were in. You guys already know what's wrong and what's right. A lot of times we just mold into situations that even things are wrong are so socially accepted. But this is the thing that these classes were involved in. And Melanson didn't just teach the class for just himself or just a few group of people. He opened the class for the whole main prison. And we enjoyed being in the class. In fact, one of the products of the class was restructuring and authoring a bill that allowed people to get their prison time before waiting 15 years for going up for the pardon board. These are the things that we did every Saturday night and all through the year. But unfortunately, like what Melanson bringing to the table, he was transferred from Angola because he didn't have a life sentence. And 15 years of being a disciplinary counsel in Angola is no excuse for getting a write-up, but boy, I hope the board don't base their decision on a transformation Malone made based on going into new environments. I've never had experience in the 35 years I spent in prison. I spent it all there. But I could imagine with my excellent conduct record, I could imagine how it would be if I had to go from one institution to the next. You know, things like that could come up. But if Melanson was still in this state in Angola, he'd probably be right on free. You know, just making adjustments and then going in front of the board. But the last thing I want to say to the board is that before Act 122, before any reasonable possibility of freedom, Melanson was working on transformation. No incentive whatsoever. And you look at his jacket, and you can see all the beautiful rehabilitation activities he got. Man, he been trying to better himself. And just like Mr. Moshawn brought to the table about being a fourth felony offender, it just get to a point where you just get tired of doing the same thing over and over.
For us. You need to wrap it up,
All
right?
right, I'll wrap it up. And I'm thank y'all. Give me the opportunity to speak.
All right, thank you for sharing that with us. Mr. Myers, can you just give us a brief statement about the parole project support?
Yes, ma'am. Kerry Myers' parole project. If this board would grant Mr. Melanson his parole and let the board know that we will provide case management services in the New Orleans area. While he won't be a residential client, our case manager, our reentry specialist, Edward Johnson in New Orleans, will provide him reentry services.
Okay, thank you. And now we'd like to hear from the DA's office.
Good afternoon, Randy Myers, Assistant DA, Jefferson Parish. If we're opposed at this time, he's got a poor supervision record, a pretty extensive criminal history. It includes a number of different drug offenses, as well as batteries and domestic abuse. Looking at his risk assessment, it does show moderate for substance abuse, depression, and education. And it's a moderate for substance abuse, and he contends he's only smoked some marijuana. When you look at the drug history, the criminal history, it's suggesting there's other things involved as well. And then the main thing is his disciplinary report. 2 reports in 22, and I think 8 in 2021 is from our position, our perspective, is just not acceptable. And not with that in his poor supervision record, we think he'd be a very poor candidate for parole. So we're opposed. Thank you.
Thank you. We appreciate the DA's input. Mr. Melanson, is there anything you want to say to us before we vote?
Yes, ma'am. I just asked the board to give me an opportunity to get out and become a law-abiding citizen and a dedicated father, son, brother, neighbor, friend, and uncle. Thank you and happy holidays.
Thank you. Mr. Roche?
Executive session, Madam Chairman.
Second. We have a motion second for executive session. Can you do the roll call?
Sure.
Yes.
Yes.
Yes. Mr. Melanson, we have a unanimous vote for executive session to discuss confidential matters. So stand by. We'll be back with you just momentarily.
You think you could win?
He picked up on it. Hmm? What?
I said, I thought he would just be ready to vote, but he just wanted to call the executive session, so it's not over.
Oh. For him to do that, he's thinking.
Even made me cry, man.
All right, Mr. Melanson, we're back in regular session. It's 12:42. We're prepared to vote. Mr. Roche will be voting first.
Mr. Melanson, based on a general disciplinary conduct that is totally unacceptable in 2021 and 2022, I'm denying your request.
Mrs. Jackson.
And Ms. Melanson, I'm hopeful for you. You've done some really good programming. You facilitate classes. But you've got to be authentic in what you do. You can't just teach one thing, but then do something else. When you deliberately get write-ups so that you could get transferred, that shows you're not applying the things that you're teaching to your own situation. I think you're close. I think you've already gone a year without a write-up, and I think that's positive. You've got good programming. I think you're going to get there. I just don't think today is the day. I think you need a longer period of time without write-ups, and I think you can do that. I think you're fully capable of conforming to the rule and presenting yourself in a totally different situation the next time you apply. So my vote today is going to be to deny because of the write-ups, but also to encourage you to keep doing the things that you're doing, stop getting write-ups, and apply when you're eligible. And I think you'll get a different outcome.
Mr. Malonso, I couldn't agree more with my colleagues. I was disappointed in the write-ups because you do have a good record in terms of your program opportunities that you've taken advantage of. I do believe you're at a spot now where that won't be an issue for you. Take advantage of whatever Warden Bickham has to offer for you. Continue working hard. My vote today is to deny based on your history of revocation, your conduct history, and of course the opposition that's been expressed. But you got a little more work to do. Reapply when you're eligible. I think you'll have a different outcome if you keep a clean record. Good luck to you, sir.
Thank you, ma'am. Thank you all.
Warden Bickham, that concludes our business at your facility. We're going to sign off at 12:45. Thanks for accommodating us.
Y'all have a Merry Christmas.
So this hearing took place on December 14, 2023. So not so long ago. At the time of this recording, it's April 14, 2024. So I'm not sure when we'll see him again. It's going to be at least a year before we see him. I think, what was the words Miss Jackson used? Did she say unauthentic? And I felt that his parole hearing was also very unauthentic, to kind of play it down. Oh no, I've only smoked marijuana when I was a teenager. And it's like, it's also interesting when dealers state that they never used it. I don't think it makes them look better as far as the board is concerned, unless they don't have the substance abuse programs under their belt and they realize that they need those programs to get paroled. So then that's why they take that stance. Then I maybe understand it. Or maybe he didn't want his daughter to think that he was abusing it, or maybe he really wasn't. But I think it makes it worse when you're a hardcore dealer and just doing it and understanding how bad it is. Randy, always there, the DA, to put in his piece. And those of you, I'm sure, are, many of you are familiar with Act 122. But for those of you who aren't, that's why the Parole Project is here. It was legislation that was lobbied hard by the Parole Project. It gives anyone who basically has a life sentence or a very long sentence opportunity for parole, as long as they are above the age of, I think, 40 and served a certain amount of time on their sentence. It basically immediately makes them eligible for parole. And that's why we saw the Louisiana Parole Project there. Let's go jump into his crime. It's quite an interesting one, how they caught him. It was a whole sting operation. So at trial, Detective Gary testified in September of 2012 that he was working in the narcotics division and he received information that caused him to conduct an investigation of the defendant. Surveillance was established and defendant was seen going to the officers referred to as a neutral location, such as shopping centers, fast food restaurants, and busy parking lots. The detective Bartit testified that dealers and users often met in these neutral locations in order to conduct transactions. The police also observed that the defendant went to an apartment complex frequently enough for the surveillance team to believe that he had access there, although a particular apartment was not notified. On September 28, 2012, while conducting surveillance, Detective Bartit saw a defendant driving a gray Chevy to the 1500 block, Harvey, Louisiana, near a Popeyes restaurant. Detective Bartit watched the defendant to see if he was just eating or if he was doing anything suspicious. Defendant later entered a business. Never entered a business. Rather, he moved from one position to another inside the parking lot and just parked. Based on that information, the detective contacted his superiors and told them that he believed a potential narcotics transaction would occur, but he left before any transaction took place. Okay. Why would he leave before a transaction took place? But all right. So he testified that he knew the defendant. Brooklyn Franklin testified that he knew the defendant through a mutual friend and that they hung out together and that she bought narcotics from him. On September 28, 2012, Ms. Franklin called the defendant when she got off work, and the defendant told her to meet him at Domino's Pizza near her home. Ms. Franklin drove to the location in her Toyota Corolla with a friend in the front passenger seat. Upon arriving, the defendant waved down after exiting Popeyes, which was near Domino's, and then got into the backseat of Miss Franklin's car. Miss Franklin moved to the driver's side backseat and purchased a bag from the defendant. The defendant then walked away, and Miss Franklin left in her car. Well, what was in the bag? I actually am curious to know what type of narcotics he was selling. Soon after meeting with the defendant, Miss Franklin was pulled over by an unmarked police car. Wow. 2 officers approached her car and ordered her out of her vehicle. Miss Franklin complied. She attempted to hide the bag she had just bought, but was unsuccessful. It rolled down, and the officers picked it up. What does that even mean? Why would she get out of the car holding it, and then how does it roll down? All this seems so sketchy. It's like they're like waiting to see someone buy, and then they pull. It's like, what is going on here? The officers also found paraphernalia in the car, a spoon, which was in open view. Okay, so if there's a spoon, this is probably Pepsi she bought. Ms. Franklin testified that she had been charged with possession of, it was the Magic Dragon. Dope. In relation to this case, and was in state of diversion program. But she said she had not been provided a deal by the state in exchange for information or testimony. So this is her testifying. So I don't get it. They have a sting operation where they watch him sell, and then instead of pulling him over, they pulled them over so that they would become a witness. Is that what it is? Detective Patrick Evans testified that he was employed by the Jefferson Parish Sheriff's Office September 8, 2012. When he received a call to assist the narcotics unit in an investigation. Pursuant to the instructions given to him, Detective Evans stopped a Toyota Corolla, which was occupied by 2 white females on Bannerwood, just off of Palco. When Detective Evans and another officer approached the vehicle, Detective Evans saw a metal spoon in the car, which he knew was commonly used to cook the stuff, before loading it into a syringe. At the time, he asked the driver, Brooke, to exit the vehicle. When she stepped out of the car, a clear plastic bag containing a brown powder substance he believed to be a heroin fell to the ground from her lap. Ms. Franklin was placed in handcuffs and advised of her rights. Ms. Franklin told Detective Evans that she had purchased it from a black male named Ray from the Popeyes at Manhattan. Agent Christy Clemson in Jefferson Parish Office testified that on September 28, 2012, she participated in an investigation of the defendant. She saw the vehicle pull up to the defendant, exit the Popeyes, and get into the rear passenger side of the vehicle. The driver, Brooke Franklin, exited the driver's side and got into the rear side of the vehicle. 30 seconds to 1 minute later, Ms. Franklin got out of the car and back to the driver's seat to appear to be putting something in her pocket. The defendant then exited the vehicle and walked into Domino's while Ms. Franklin left in the car. For her position, Agent Clement could not see exactly what Mr. Franklin put into her pocket, but based upon her past experiences, it appeared that narcotics transaction. I mean, they're just going over all the different. Let's see. Okay, Agent Clemente also participated in an interview of Brooke. Ms. Franklin was advised of her Miranda rights, and Ms. Franklin indicated that she wished to waive her rights and cooperate. Why do so few understand the power of saying attorney? Ms. Franklin then told, what were they going to get? They were going to get her for possession. Ooh, Ms. Franklin then told Agent Clement that she purchased the stuff from the defendant on several occasions. She stated that she sometimes purchased it from him at apartment of Bellamade, and she was aware of the location of the apartment. Ms. Franklin also said that the defendant had 50 to 100 bags of the stuff with him when she bought it from him that day. When questioned about the defendant not having anything on his person when he was arrested, Ms. Franklin said that she may have been confused. Oh, this is interesting. So she said he had 50 to 100 bags, which again, this seems like someone who's trying to play up. Maybe she knew exactly what she was doing by saying, I don't want an attorney. She was playing it up to try to get out of it. She had to make him a big dealer, right? To get out of her little possession charge. That's my assumption. But when questioned about the defendant not having anything on his person when he was arrested, Ms. Franklin said that she may have been confused because she had also purchased from the defendant earlier in the day. Ms. Franklin described the defendant's vehicle and later pointed out the defendant's apartment to police while in custody after physically traveling to the location. Let's think about this. When he was arrested, had nothing on him. Holy cow. She then says he had 50. So he's smart to literally show up with just whatever he's going to sell, one small bag, or he just wasn't a big time dealer. I mean, and they locked him up for so long. Wow. I mean, welcome to Louisiana. Let's read more. After the defendant was arrested, Detective Bartil learned that the defendant was attempting to have family members remove items from his apartment and retrieve money for his bond. The detective obtained a search warrant for the apartment because this apartment had been identified as belonging to the defendant. During execution of the search warrant, several items were discovered, including a 9mm semi-auto pistol with a loaded magazine, case with spare magazines, various documents, 2 clear plastic bags with brownish powder that tested positive, 1 larger clear plastic bag with brownish powder that tested positive, digital scale and brownish powder, bottle of GNC in a still a blender, brownish powder, Samsung cell phone, $20,000 in cash. Wow, that's a nice score, dude. But really, they didn't find anything except for the weapon. They didn't find, again, stuff that said he's a major dealer. Margie testified that she was a property manager of the apartment, that her office was on the premises, that she also resided in the apartment complex. She was generally familiar with the comings and goings of people who rent the apartments. He was a leaseholder for the apartment that was listed as her employer. However, during the 6-month rental period, Mr. Barfield only saw McGinnis 3 times: when she applied for the apartment, when she signed the lease, and when she gave notice the apartment would be vacated. That's interesting. Okay. During the entire term of the lease, Miss Barfield never saw anyone drop by the apartment other than the defendant. She also saw the defendant driving vehicles that were listed in the apartment registration. I mean, they really don't have much on him. I mean, like residue, he should have just said that was for personal use, right? Gosh. Are they saying that the family members got that stuff out, but they wouldn't have gotten the weapons out? This is, this is sketchy. Not saying that he's not guilty, but just sketchy that a jury would find him. They have one witness who is very clearly motivated to testify. I guess they had witness. I don't know, man. The jury heard evidence of Miss Franklin's drug use both during and after her arrest. Also, that Miss Franklin was placed in a diversion program. When the issues of a witness's drug use is brought before the jury, defendant, it is jury's discretion. I mean, like as Dr. Grande would say, I think he's, guilty in reality, but not guilty beyond a reasonable doubt. In the present case, the jury apparently found Miss Franklin's testimony credible in spite of testimony about her drug use and diversion program. She had every reason to lie. Who were to say they didn't get in a car for whatever reason, and she happened to have it on her? I mean, like, I just don't get it. And anyways, it's such a small amount. I hate how many times it lists that address. I just hope YouTube won't do anything about it. It's obviously an irrelevant old address, not assigned to anyone right now. But it still creeps me out. Um, and then, of course, they got him as the habitual offender. And that's what Louisiana does, right? You know, if only he had harmed a child, he'd be out 10 years ago. What do you think? How do you feel about this? I don't feel someone like this should get forever time, like the time that they gave him, even though he's a habitual offender. I also don't really like how it seems that there's very little evidence for this particular crime to get him. It's like you want to lock him up, then get him fair and square, but don't. It seems like they didn't really have that much evidence that he's a big time dealer. It's just my opinion. They could have done a better job, right? I don't know. Love to hear your thoughts. Thank you, Richard, for the info. And with that, I'll let you go.